Item 25.
May it please your Lordship.
Yes.
My Lords, I have challenged a tender, my Lord, which was issued by the government of Mizoram for, my Lords, outsourcing 7 hydro projects, combined capacity around 26 megawatts. My Lord, interestingly, in the tender, they have excluded bidders from participating as consortiums or joint ventures.
Okay.
For no apparent reason, my Lords. In fact, I have pulled out, my Lord, similar tenders in other areas, my Lord, Sikkim, Uttarakhand, Himachal, where, my Lord, provisions are there. You can participate. Bidders can pool in their resources and participate as either joint ventures or consortiums. There is no intelligible difference.
Where is the tender?
Lordship. Annexure 1, my Lords, has no provision, my Lords.
It does not have a provision.
Not at all, and they have now confirmed to me, saying yes, we will not allow JVs or consortiums.
Where is that confirmation?
My Lord, that document, I'll just, my Lords, I got it yesterday. My assisting counsel has it, my Lords.
Okay, have your papers ready? We'll take it up after some time.
Lordship, grateful.
And who's appearing for the respondents? You are appearing for the respondent? You have your reasons for doing so?
Your Lordship, in this regard, I would like to take at least 2 days
Because
to
you
find
see
instruction, to have instruction. Your Lordship.
when the matter was mentioned yesterday, they said that the last date is 29th.
That's it.
The thing is that yesterday only we received the petition and we didn't have time to receive the instruction.
Why are you coming at this last moment? When was the tender issued?
My Lord, tender, I'll just tell your Lordship.
When was the tender issued?
My Lord, the tender was issued on 8/8/25.
8th of August.
Yes, but my Lord, I had purchased on 20th of August.
I'm not interested when you purchased it. If it did not have a clause, and if you thought it was wrong, then you should give everybody some time to breathe. Find out what it is. Every case, if you think that you will come at the last moment, put a pressure.
No, but the confirmation may not be received.
It's not about the confirmation. If you are challenging the tender,
Lordship,
saying that it does not have a clause and I'm not being allowed to participate.
I can explain, my Lords, just in one sentence. My Lord, 8/8 tender gets issued. My Lords, there is no provision, but it says you have to pay 10 lakhs non-refundable for purchasing the complete bid document. So I do that on 20th August.
Knowing that it does not have a clause for...
So, my Lord, then they call us. I thinking that when I purchase the complete document, it would have some clause. Just one thing.
Let your document come.
There was a pre-bid meeting on
your
12th.
Let your document come. We will not hear the arguments twice.
Lordship.
Jailer list for admission, item 1.
Yes. Where is the implement order? The order which
I
is
was
not...
supposed to file an affidavit by enclosing my instruction letter. Then I may be filing today, my lord.
You are filing the affidavit today.
Yes, my lord.
This matter is relating to what? The orders were to do what?
It's for payment, my lord. Payment
Of?
of rental compensation.
Of?
Rental compensation. For occupation of land.
Okay, they occupied your land and they have not paid you the rent.
My lord.
You can wait for a week. Let her file the affidavit.
Lordship,
Because, see,
That-
if we now hold them in contempt also, suppose,
my lord,
it is not helping you.
that is true. But
The-
the problem is, my lord, they've asked for 8 weeks for compliance on 10th of February.
Yes. Okay.
And the affidavit they're filing now is only saying that it's under process. So,
My lord.
Contempt, we are a bit, because it relates to the
My lord,
8 weeks time to comply. Who has to comply? Who is the person who is required to comply?
respondent number 14.
Respondent number 40. Who is he? There is only respondent number 8. Who is respondent number 40?
no, it would be respondent, the contender number 3, Your Lordship.
Contender
Because,
number
that,
3
they're
is
the
the
authority to
No.
issue the.
Director, Ministry of Home Affairs. He's going to give you the rent. I don't think so.
They have to issue the amount.
Res-
It has already been forwarded to them.
Respondent number 8.
We are not concerned whom it is forwarded to. We are concerned with who is required to pay. Respondent number, this is the order, page 27.
Lordship.
Please see. 1, 3 and 7. Yes. Who is 1, 3 and 7?
Home, Your Lordship. Home, Assam Rifles. Ministry of Home and Assam Rifles.
The respondent in the writ petition, 1, 3.
One is the Secretary, Home.
3 is the
Ministry of Home.
director,
3
7 is the
Director,
commandant.
2.
Yes, your commandant can be here tomorrow morning with all the documents. Why it is not being complied with? We will not get the secretary or the director now. The commandant can come down from Lungle.
Your Lordship, the
Because the
problem
direction was to the commandant who shall deposit the said amount within a further period of 4 weeks. Commandant was the person. What
Yes,
is it?
my
Has he
lord.
filed his affidavit?
We are supposing to file affidavit on behalf of respondent number 8.
No, the commandant. Who is the commandant?
Commandant.
Yes, this respondent number 8.
20 Assam Rifle. Commandant 20 Assam Rifle.
Mm. He's still there. Colonel Vijay is still there. Vijay R. Who's the person who's signing the affidavit?
Now, Jaswinder Singh. Jay Singh.
Jaswinder Singh is not a party here.
Okay. Then we'll make some application.
What does did Colonel Vijay file any affidavit?
My lord, did only respondent number 8.
Colonel Bijoy R.
No affidavit by him. And this person who's signing the affidavit now, the commandant now, is not a party. So,
So in the meantime, let me make my let me make an application.
yes. Apparently, since he's filing an affidavit, he already knows that the matter is what the matter is about. Since he's filing the affidavit,
My lord.
unless he's a party, we cannot pass any orders. Is it not? So we'll have the matter listed. We'll have the matter adjourned for today at your request, and you may take necessary steps to implead whomsoever you want to.
Right.
Is it? Otherwise, in a contempt petition, hands are tied. At the request of Mr. So-and-so, Learned Counsel appearing for the petitioner, the matter is adjourned for a week to allow him to implead necessary respondents. Full stop. In the meanwhile, the respondents may file their affidavits in their affidavits showing cause as to why contempt proceedings shall not be initiated against them. You also file your affidavit in the meantime. Yes.
Obliged.
Item 2.
My lord, in item 2, I was supposed to clarify whose counsel will be defend the case, because even I file affidavit for the respondent. However, later on, one counsel filed Bakarlan Ma. Then he received.
Then who is appearing in the matter? Who would be
Yes.
appearing in the matter?
My lord, till date, even I sent letter to the concerned department. Till date, I didn't receive any instruction in this regard.
And they did not take your NOC also while appointing the other person. Make a complaint to the Bar Council. No. Yes, where is that impugned order? The order of which compliance has not been made?
Yes, my lord, it is at page number 12 of my contempt petition, my lord. Order dated in 19th March 2020 in WPC 148 of 2019. The operative portion is...
Just a minute.
Yes, my lord.
It becomes so difficult to trace out the documents. They're not putting it in serial. See, I'm trying to find out the... do. Kindly give me the contempt petition. Where is it? Show me the contempt petition. We'll have it after some time.
My lord.
Item 3.
Yes.
My lord, rejoinder affidavit has finished preparation, and we may give out the copy to my learned friend, and I may submit latest by tomorrow.
So, take down, say so-and-so appears for the petitioners and submits that the rejoinder affidavit has been prepared and will be filed during the course of the day? Or
Course of the day,
will be filed within,
latest
a
by
week?
tomorrow. Latest by tomorrow.
or will be filed by tomorrow, by tomorrow? According to the matter after the vacations. You want to file? It's a rejoinder affidavit.
No, rejoinder affidavit against the additional affidavit filed by the respondent number 4.
So list the matter in the first week of November for consideration.
Must oblige.
Item 4.
My lord,
Yes, sir.
I may be allowed to file rejoinder affidavit against the affidavit in opposition of respondents 1 to 4. Affidavit in opposition filed by respondents 1 to 4 against the recast petition, my lord, recast writ petition.
Against the?
Recast amended writ petition.
Okay, recast it.
Yes. So I may be allowed to file rejoinder.
Mr. So-and-so, Lord Counsel appearing for the petitioner, pays for 3 weeks' time to file the rejoinder affidavit to the affidavit in opposition filed by the respondents number 1 to 4 against the recast writ petition. List after filing of the rejoinder affidavit.
Much obliged.
Item 5.
Yes.
My lord, the petitioner wrongly mentioned the name of respondent number 2 and respondent number 3. However, the person who are holding the post of this respondent number 2 and 3 is different person, my lord. If I may submit my instruction.
Were they holding the post at any point of time earlier? Were they holding the post any time before this?
My lord, I was not informed.
Where is that order which you are complaining?
Page number 8, my lord, annexure 1.
Oh, this is the family pension part? No, 2 pensions. Director General, Deputy Director Administration. Miss, take down. Miss so-and-so appearing for, you are appearing as a CGC?
Yes, a private person, my lord, private
No,
counsel.
no, this has come to you as the CGC.
Yes, my lord.
They have not sent you a wakalatnama, have they? They have
Yes,
not given you any
not yet-
wakalatama?
Not yet filed wakalat number for respondent number 2 and 3, but I already filed for respondent number 4.
Okay, now submits that. The respondent number 2 and 3 are not the appropriate authority,
Yes,
no?
my lord.
That the respondent number 2, that the officers holding, that the respondent number 2 and 3 are not the persons holding the posts described in the memo of parties. Full stop. Ms. Sensors also entered appearance for the respondent number 4. You are appearing for respondent number 4
Yes,
also?
my lord, I already filed my affidavit for respondent number 4.
The counsel for the petitioner seeks for some time to verify and make appropriate amendments so advised.
Obliged.
List the matter after 2 weeks. You make your amendments, then the persons are not the correct persons.
My
Apparently.
lord.
Item 6.
here the pleadings are complete, my lords, it may be listed for hearing after the ensuing vacations.
It is submitted on behalf of the parties that the pleadings are complete in the matter and the matter may be taken up for hearing. Full stop. Accordingly, list the matter in the hearing list in the month of for the week of yes.
November.
Which
my
week?
lords.
Huh?
November.
November what? You have a weekly list, I believe.
Yes, my lords.
Then second week of November.
Which one?
Item 7.
My Lord, notice is complete and let the matter be heard of merit. Let the matter be heard of merit.
We'll put it in the hearing list. Should it go to the hearing list?
Yes, my Lord.
Okay. It is submitted that the pleadings in the matter are complete. Stop. With the consent of the parties, let the matter be listed in the hearing list in the third week of November.
Yes, my Lord. Much obliged.
Item 8.
My Lord, I am appearing for the petitioner in item number 8.
Yes.
We have taken steps on the private respondent number 1 and 2, my Lord. And as per the office noting, the ID card for respondent number 1 has yet to return.
Who is the respondent number 1? Okay.
They are private respondent, my Lord. So,
Anybody appearing for respondent number 2? Although AD card in receipt of the notice issued on the respondent number 2 has been received back, there is no representation. Full stop. The report on service of notice on the respondent number 1 is still awaited. List again in the second week of November.
my Lord, there is an interim also on this matter. If it can be extended, listed the
in
next
the
day.
month of, in the second week of November with service report, interim orders if any to continue.
My Lord.
Item 9.
Service report on the respondent number 3, interim orders passed earlier shall continue.
Item 10.
Yes, item 10.
My Lord, it seems that notice is complete. Notice is complete.
You are appealing?
Yes.
You are appealing for whom?
For the respondent.
How many respondents?
Only one. For the sole respondent.
Mr. Swenso has entered appearance on behalf of the sole respondent. Full stop. Service of notice is thereby complete. List this matter for admission.
My Lord, if I may.
Yes.
Yes. Along with this appeal, we have filed one IA, that is stay of the operation of the impugned order. So, if stay.
What was the order? You are restrained from interfering in the suit land.
Yes, yes. So
if you pass a stay order on this, then you will be allowed to enter into the suit land.
See, the problem is, my Lord, in the main suit, what they pray is for possession of the suit land.
Okay.
So, debarring us from interfering is more or less the same with granting of the main relief.
It would have been better if there was a status quo. Not a restraint.
See, the suit land, the suit building is.
Yes, please go on.
Yeah, used as renting out to some other person. So we are completely debarring from collecting the rent and from the tenants itself. So
you are the respondent.
yes, in the main suit.
In the
yes.
main suit, you are the defendant.
Yes, I'm the defendant.
And you are not in possession. You are collecting rent from the people.
That portion, the suit land is rented out to several persons for garage. So,
But he has come to a finding, the learned trial court has recorded that she is no longer in possession of the suit land.
I am in the possession of the suit land. See, I am having control over the suit land until this order is passed. I
So
collect the rent.
don't go into the suit land to take the rent. Call them outside to take the rent. Simple. Why should you interfere at this stage?
My lord,
Have you filed your response to the IA?
No, not yet, my lord.
We'll list it immediately after the vacations.
Yes.
You file your response to the IA.
Yes.
We'll take it up for, because without his
yes.
response, if I put it up, then you'll have to go one more floor higher.
Okay.
Yes. So-and-so has entered appearance on behalf of the sole respondent. Learned counsel for the appellant has submitted that there is an IA civil number 132 of 2025 praying for stay of the operation of the impugned orders, of the orders impugned in the appeal. Learned counsel for the defendant prays for 2 weeks' time to file his response to the IA. List the matter in the 4th week of October along with the response to the IA for consideration.
Highly obliged.
Yes.
Item 11.
My lord, in item 11, I'm there for the petitioner again. Here, my lord, there's one private respondent and one state respondent, and the ID card for the private respondent is yet to return, my lord.
On the respondent, list again on the 2nd week of November, awaiting service report on the respondent number 1.
My lord, there's an interim in this.
The interim order, if any, shall continue.
Item 12.
Miss.
Lordship, I'm appearing on behalf of the respondent number for counsel, Mr. Tira Zikima. He's on next.
He's on legs.
Yes,
We'll
my
have it
lord.
after some time.
And my lord, he had requested me that they will file an arbitration petition as allowed by the review orders, and will submit an IA during the course of the day for incorporating with the filing of the arbitration petition.
No. I did not get you. Yes? Can we have you again?
Yes, my lord. That the NHIDCL had filed an arbitration petition as allowed by the review order, and they will submit an IA.
That order has been reviewed. The order in question.
Your Worship, in the writ appeal, they were directed to, in the writ appeal, there was a direction to the NHIDCL to deposit the amount with the competent authority, and so that it can be disbursed. In the review, Your Worship, the only modification made is at para 12, that they can approach the arbitrator for protection under section 17 of the Arbitration Act.
Have you made the deposit?
They have not made the deposit yet. They can only ask for protection under section 17 regarding disbursal of the amount. The direction regarding the deposit of the awarded amount within 1 month in the writ appeal still stands.
We are aware of the fact that there has been no disbursal of the amount in favor of the petitioner. You did not point it out to during the review petition that they have not deposited the amount. You should have pointed it out then.
Yes.
Because the this review is proceeding on the basis, we are aware of the fact that till date there has been no disbursal of the amount.
Yes.
So it was presumed that they have already deposited the amount, but it has not been disbursed.
So that they have been given liberty to approach the arbitrator for protection under section 17 of the Arbitration Act.
We'll list this after the vacation.
Yes.
When is the arbitration scheduled next?
Your Worship, in fact, today is listed for submission of written statement.
Then
30th is the...
If they do not get a stay under section 17,
Well, I mean, they can get a stay regarding disbursal, but regarding depositing the awarded amount, there is no stay. It is only for protection regarding disbursement. Conditions may be imposed, but regarding depositing the awarded amount, there is no modification of the rate of Honorable Division Bench judgment. It's only regarding protection.
the counsel for the petitioner has submitted that the orders directing depositing of the awarded amount. What amount?
Your Worship, as per the award dated 17th of
The awarded amount.
award dated 17/4/2021.
What did we say, Leonard? Amount have not been interfered by, or has not been interfered with till this stage, and yet the respondents have not deposited the amount as required by the order dated 24/10/2024 in writ appeal number 10 of 2024. Full stop. The learned counsel appearing for the respondents has submitted that in the review petition by order dated 28/7/2025 in review petition number 2 of 2025, comma, the respondents have approached the arbitrator, and therefore there is no willful violation of the orders of this court. Full stop. We notice that by the order dated 28/7/2025 passed in review petition 2 of 2025, this court had observed that the directions passed by this court to disburse the amount by the competent authority shall not affect the powers of the learned arbitrator to pass in appropriate interim measures in terms of section 17 of the Act if an application is filed before the learned arbitrator and the case is made out for issuing interim measures. You will find that in this, see, this review petition, last page, that is page 9, I am underlining, okay? Full stop. We have not been informed, this court has not been informed as to whether any application under section 17 has been moved. Be that as it may, since there is, since the order dated, what was that order dated?
24/10/24.
24/10/2024 in writ appeal number 10 of 2024, to the extent that it required the respondents to deposit the awarded amount, has not received any interference or has not been modified as of date, comma, the respondents on the next date shall apprise this court as to why the said deposit has been not made. Stop. List the matter again on 18th of November. What name?
So the 18th is
On the 4th of November.
4th of November.
Yes.
Sometime
You want it
in
earlier?
Sometime
Okay.
in October. Yeah.
October. On the 29th of October?
Oh.
On the 29th of October, to allow the counsel for the respondents to have his instructions.
I'm okay.
On the next date, you have to inform why you are not depositing it.
Yes, my lord.
Item 13.
30 RFA. Yes.
Please, Your Lordship. My Lord, by way of this appeal, we are challenging one order passed by the Court of the Senior Civil Judge in miscellaneous application.
No, whether service of notice on respondent number 2 is complete.
I apologize, my Lord, that I did not check up.
It
But
says
we had-
here, an affidavit of justice service upon
Justice
1 and
service
2 has
we-
been filed.
We have
Respondent
submitted our-
number 1 has been represented. However, respondent number 2 is not yet represented. So, when did you serve the notice?
We had filed our affidavit of service on 26/8/2025.
26/8/2025.
Yes, Your Lordship.
1 month not over. We'll give him one more opportunity to
Fair enough,
appear.
Your Lordship.
The respondent number 2.
Fair enough.
Although the learned, although an affidavit has been filed on behalf of the petitioner showing service, completion of the service upon both the respondent numbers 1 and 2, comma, and there is a representation on behalf of the respondent number 1, comma, there is no representation on behalf of the respondent number 2. list the matter again on. What is the urgency in the matter?
Slight urgency is there, Your Lordship. If we
Again
can,
on,
week commencing from the 6th, Your Lordship, after the vacation.
on the 9th of October?
Yes, Your Lordship.
On the 9th of October, allowing the respondent number 2 one more opportunity to enter appearance and contest. Yes.
Obliged, Your Lordship.
Item 14.
May it please Your Lordship, I am appearing on behalf of the state respondents.
Yes.
Your Lordship, this is the second time this matter has been listed. We have not received pairwise comments from the state respondents, Your Lordship. So if 3 weeks time may be granted, Your Lordship.
What is the subject matter? What is the
My Lord,
subject
Your
matter?
Lordship.
It's regarding a claim for compassionate allowance and encashment of unutilized earned leave.
Okay, the person was initially terminated from service, then he was reinstated, then he was again terminated. That one?
Correct, correct.
And now he's asking for compassionate allowance. Why was it rejected on the ground? What was the ground of rejection?
Continuous absence, my Lord. A long continuous absence. Yeah, my Lord, I'm appearing on behalf of the counsel for the petitioner. He's out of station at the moment.
No, we'll allow them time to file the affidavit in opposition. I was just trying to see what was the matter. Did this person also approach the court? Yes. Again. Okay, let the counsel for the respondents pray for 3 weeks' time to file their response to the writ petition. Time is allowed. List the matter after 3 weeks along with the affidavit in opposition to be filed by the respondents.
Much obliged, Lordship.
Item 15 for
This has been approved. It working. Just a minute. Okay. Yes, item 16. Yes.
Well, this is a criminal petition filed by the state against discharge order. And there are 3 respondents in this case, my lord. 1 and 3 are represented by my learned friend here. And the respondent number 2 is Myanmarese national, my lord. And she's in Myanmar. Notice cannot be served. And this honorable court has passed an order and directs the state police to do the needful. However, my lord, I have received back the summon. They said that it's not within their jurisdiction and they cannot serve.
No. When we say that you do the needful,
Yes, my lord.
this, from what I have seen or experienced, this has to go to the Ministry of Home Affairs.
Okay.
Ministry of Home Affairs will have the letter sent to their embassy. From where it will go to their embassy, they will try to serve it and send back a report. If the man is not traceable there, the report will come that he is not traceable here. And if they can trace him, they will serve him.
All right.
So that one attempt, I think, has to be made. The police cannot go into Myanmar to serve it, that is obvious.
Yes, that's certain.
But this has to go to the Union of India, Ministry of Home Affairs. That this is a court case. Find out, there must be some procedure given. There is a court case and we need the presence of this person, we need to notify him. They will take necessary action. And if the government of India refuses you, bring that on record. That we made up. But this is not helping.
Yes.
Have you filed your response?
Yes, my lord.
You have filed your response?
Yes, my lord.
1 and 3?
Yes.
The learned public prosecutor appearing for the applicant has produced a letter dated 18th of August 2025 issued by the officer in charge, Champai Police Station, that the last known address of the respondent number 2 is not under the jurisdiction of the Champai Police District, Police Station, Champai District, since the address has been shown to be Myanmar. The learned PP plays for a further 2 weeks' time
Yes, madam. Yes.
to enable her to take alternative steps to serve notice upon the respondent number 2. Prayer is allowed. List the matter again. We'll keep it on the 3rd week of November.
All right, madam.
Give a date on the 3rd week of November, by which date
18th.
an updated status would be produced. Yes?
18th.
18th of November.
All right.
I'm giving a longer date because it has to go to the Ministry of Home Affairs and come back.
Obliged, madam.
I may not be entirely correct. Find out from.
I'll try to find out also.
Item 17.
My lord, paper book had been received.
You received now?
Yes.
Okay.
I have received the paper book.
So
Your
we'll list
Lordship,
it for hearing.
I haven't received the paper book.
This jail appeal.
Huh?
Jail appeal.
Jail appeal, but she would require a paper book.
Yes. It may be listed for hearing. In the meantime, I can make a copy for her, my lord,
Huh?
if necessary.
Okay. The learned PP appearing for the state has submitted that. But it is said here that the registry is saying that it has been submitted, it has been supplied to both the parties. Okay. Miss so and so appearing for the state, learned PP appearing for the state has submitted that she has not received the paper book. Full stop. To expedite the matter, the learned counsel appearing for the appellant has agreed to supply a copy of the paper book to the PP in case she does not receive it prior to the next date of listing, comma, full stop. List this matter again on
After vacation, my lord.
15th of October.
My lord.
No, 15th is a motion day. 16th of October.
My lord.
16th of October for consideration. If you do not get it from the registry, he agrees to give you a copy.
Yes, Your Lordship.
You anyway give her a copy. That will be easy.
I'll provide, my lord. It's obliged.
Item 18.
Yes.
Lordship, I am appearing on behalf of my senior Mr. Johnny L. Tauchong, who is on leave right now, my lord. And as per his instruction, my lord, we have received affidavit in opposition from the respondents, and if the matter may be listed after the vacation for IA hearing, my lord.
At the joint request of the learned counsel for the parties, list this matter again immediately after the vacation on a date to be fixed by the registry.
Item 19.
With regards to this, my lord, the ID card is still awaited, my lord.
List this matter again in the month, in the 2nd week of November, awaiting service report on how many respondents are there? On the sole respondent, huh?
There are 2 respondents, my lord. Very similar names.
Interlocutory application, there is only one. How many respondents? Oh, and another, acha. Awaiting service report on the respondents. Yes, I missed the word another.
Item 20.
This is an application for substitution of the appellant. And as per the last order, the notice upon respondent number 5 was served to Dusty. And the Honorable Court had held that since the service was very recent and no one has appeared on behalf of the respondent number 5, so some time may be awaited. Otherwise, notice is complete. And this is just an application for substitution of the appellant by his wife. He passed away during the pendency of the appeal.
During the pendency he passed away?
Yes.
When? Three to 2025. What was the time limit? 3/2/62. Yes, what is the objection in allowing the substitution? Any objection? Respondent number 5 is otherwise appearing in the main.
He appeared before the trial court.
He is not appearing here also in the main.
He has not appeared here. He contested. I mean, he was a defendant.
Yes, in the appeal notice had been issued.
Yes, thus the service was allowed, and
yet
as per the last order, if your Lordship will see the last third last paragraph, as per the office note, he has already received it. Thus the service has been.
Yes, any objection on this
No, Your
substitution?
Lordship. For the state respondents, no objection, Your Lordship.
They are paying for the state respondents.
Okay, we'll allow it then. We'll allow the substitution. And you have to file an amended memo of parties?
Yes.
An amended cost title?
Cost title.
We'll pass the order in the chamber, we are allowing it. So the IA disposed of as allowed.
Item 21.
My Lord.
Yes.
If permit, may please be allowed to file additional affidavit in IA.
Additional affidavit?
Yes,
but
ma'am.
they've already filed their objection. We'll bring on record
permit.
what?
If permit.
No, you must tell us what would be the issue. Learned counsel appearing for the applicants.
Yes.
You're appearing for the applicant.
Yes.
For the applicant has prayed for 2 weeks' time to file an additional affidavit in the IA. In the IA, you want to file
Yes,
it in the IA?
yes, madam.
Additional affidavit in the IA. List the matter after 2 weeks, allowing her to file the additional affidavit as prayed.
Item 22.
My Lord, as directed, I have taken steps upon the sole respondent for service of notice on 6/8, my Lord. And as per the office note, my Lord, postal receipt is received, but the ID card has not returned, my Lord.
List in the second week of November awaiting report of service of notice on the sole respondent.
Sole respondent, my Lord.
On the sole respondent.
Obliged.
Item 23.
Yes.
Lordship,
Yes, Lordship, I am here for the respondent number 1. And my Lord, if we may kindly be granted another 2 weeks' time to file a written objection.
There's a slight delay of 112 days.
112 days of delay, my Lord.
112 days?
Yes, my
or
Lord.
12 days?
112.
112.
112. What is the ground you have given?
My husband was not keeping well, so I am the sole taker of my husband. That's why I could not immediately engage a new counsel.
Any serious objection to that?
Yes, my lord, we have a very strong objection in this IA.
When a counsel is praying for the respondents, pray for and is granted 2 weeks' time to file their objections to the application for condonation of delay. Full stop. List the matter after 2 weeks.
Obliged.
Item 2 for admission.
Item 2, contemptuous. Someone appeared. Item 2. Oh yes, oh yes, oh yes, oh yes. This one. It looked different, no, I thought it was something else. Okay. Yes, where is that order?
Yes, my lord. It is at page number 12 of my contempt petition, my lord. Order dated 19 March 2020 in WPC 148 of 2019.
Yes, madam, what has been done in this? You were required to constitute a verification team.
Yes, my lord. Thereafter.
Then there was supposed to be a report.
Yes, my lord.
And then a decision within 2 weeks from the date of verification as to whether you want to acquire the lands.
Yes, my lord.
Then
So verification was the team was
done.
Yes, was constituted, and thereafter verification was done 4 times, my lord.
Okay.
So the last verification was done on 15/9/2021. Report was submitted on 20/9/2021, wherein all parties were present, my lord. So the amount of damage was measured, and accordingly, the respondent number 1 formulated the assessment for compensation with respect to the lands belonging to the petitioners, my lord, which is at page number 51 and 52 of my contempt petition. So the amount of compensation to be paid by the respondent number 2, which has been replaced by number 5, is 48,42,000 for P Pata number 58 of 2005, and 3
that
lakhs.
has not been paid to you.
It has not been paid
Yes,
to me.
madam, why is it not paid to
My
her?
lord, on 27 September 2024, respondent number 5 filed affidavit wherein he stated that there is no any willful disobedience of this
There
court
is,
order.
yes.
However, the assessment made by the state respondent is not in order of the court order dated 19/3/2022. Then we pray to reassessment.
Where does it say that the assessment is not correct?
It was stated in my affidavit para 15.
When was the last verification done? 2020?
2021 15/9, my lord.
No. And what has he done after this affidavit?
My lord, thereafter they engage another counsel. He may be updated me.
Whom have they engaged?
Sanjay Kumar Medi, my lord.
Huh?
Sanjay Kumar Medi, SK Medi.
Respondent number 5.
Yes, for railway, my lord. Respondent
But
number.
you are appearing for respondent number 5.
Yes, my lord.
And they have not withdrawn your wakalatnama as of date. Is his wakalatnama on record?
Yeah, my vakalat nama is for respondent number 5.
No, Mr. Medhi's. There is no other Wakalatnama. This is Madam appearing. She is appearing in the matter, right? On 11th of September 2024. I'll just have a look at the order. Okay, take down Kiwi. So they have confirmed with you that they are engaging another counsel?
Not yet confirmed, my lord. Even I sent letter to them. Not yet confirmed.
On 8/9/2025, this court has noticed that the arranging of funds by the respondent number 5 as well as disbursing the amount is left to be complied as per the directions in the order dated 19/3/2020 full stop. On that day, a submission was made that the respondent number 5 has engaged another counsel who has filed the Wakalatnama full stop. Please find out if there is any Wakalatnama by the other counsel. On perusing the records of the case, no Wakalatnama for any other counsel is not found on record. Oh, then you cut out that last line. Cut out that last line. Okay. It appears that a Wakalatnama had been filed on the 23rd of February 2025 by the respondent number 5, full stop. However, the cause list does not reflect the name of the newly engaged counsel for the respondent number 5. Stop. The earlier counsel appearing for the respondent number 5 has also not filed any application for withdrawal from the case. You have to file an application for withdrawal from the case. Now that some other other advocate has been engaged, then we can allow you to withdraw.
Yes, my lord.
Has not filed any application for withdrawal from the case. Full stop. In view of the above, let the name of Mr. S.K. Medhi also appear in the cause list as counsel for the respondent number 5 on the next date of listing. It is clarified in this order itself that in the case of any further confusion regarding representation of the respondent number 5, in case it is clarified in this order itself that in case there is any confusion relating to the representation of respondent number 5, appropriate orders would be passed requiring him to be present in the court to explain the circumstances under which the orders of this court passed on. What is the order of the court? Passed on content case
19/3/2020.
19/3/2020 has not been complied with till date. List again on in the third week of November
My lord,
2025.
if it may be listed after the holiday, my lord, this has been...
Immediately after the holiday?
Yes, my lord.
Okay, then you list it on the 24th of October 2025. The holidays, oh, here the holidays are till 3rd, no?
Yes, my lord.
No, let it be on the 24th because that SK Medhi probably is from Guwahati.
Yes, my lord.
We have vacations there till the 10th.
My lord.
So he may be in the holiday mood. Post-holiday mood. Any more?
Yes, Lordship. Supplementary list, item 24.
Yes, the contract matter. Is that the one? No. The criminal petition, yes. Could you get hold of?
Yes. Well, Lord, we have informed the Respondents' Council. So if he is not available today, and then we requested him to send his junior, but none appears. But my lord, in item 18 and 19 of the daily list, his junior was appear, my lord.
Your condition was, what is the change in the condition you want? That family member, that was the one?
Yes, my lord.
Where you have been required to give the surety of family members.
Family members of LDC. And my lords, regarding the condition number 1, that the
3
bail
lakhs.
amount was too excessive, my lord.
3 lakhs?
3 lakhs, my lord.
Looking at the,
yes.
If we assume the business you have been carrying on, that is...
Because they are just a farmer.
See, it will be upon the lower court to find out as to what could be a reasonable amount. We don't want to impose on that. So far there is an apprehension that the surety may not be possible by family members living here. That we can look into. But the amount, because the amount is what is going to bind you to come down to the court every day. Is it not? So the trial court thinks that yes, this is the amount by which these people will come. How can I interfere there? I can say, I can say that okay, the where is it? This one member of the family of the accused. No, you need one permanent resident of Aizawl.
Yes, my lord.
And you need one surety.
Not below the rank of LDC, from the family members.
But he is not required to be from Aizawl. He can be from Manipur. Where is that condition? No. One surety shall be a permanent resident of Aizawl.
My lord.
Living in his or her own house.
My lord.
That is one.
Yes, my lord.
Second one is one surety shall be a permanent government servant.
My lord.
Not below the rank of LDC.
Yes.
One of the family members of the accused. So have you made a statement that no one in his family is holding a permanent government job?
No, my lords, they are just farmers. They clearly stated.
Have you stated?
Yes, my lords. In page 99, my lords. Page 99 of the application, my lord, petition. That is the statement made by the...
Page 99?
Yes, petition number 1, my lords. At point number 2, my lords. Point number 2. What is your profession? Give your financial details and your immovable and movable property details. I am a farmer by profession and help my parents and family members in Arjun cultivation.
That is why she has given that condition. That condition has been given. All unemployed, no saving account, no movable or immovable property. How to track you? How to ensure your presence before the court?
So, my lords, this bail application was bail was granted by order dated
What we will do is-
16/7.
What we will do is, we will remand the matter back for a reconsideration on that clause,
My lords.
where maybe the trial court can convert it to a relative, a person related through family.
My lords.
Will that do? Someone in your cousins, your relative, someone has a government job, you have to convince him.
My lords, just one submission, my lord, humble submission. My lords, this bail order was issued on 16/7. Now more than 2 months.
You have approached.
We cannot meet
related-
the condition, my lords.
You have come delayed. 16/7, then the entire month of August went. We are at the end of September. I think we took it up on last Monday only or Tuesday. We are trying to help you. Or should we say that it can be a person related to you through family? But those conditions we are not interfering. The 3 lakhs we are not interfering, and we are also not interfering that one of them should be a permanent resident of Aizawl. And the other condition that he should be a government servant not below the rank of LDC,
My lord.
but maybe not directly your family. That we can say. Related through family. That relationship you have to then bring in. What do you say? If that suffices you, then maybe we can. But in the absence of the PP, again we cannot. We'll list this matter on the 6th. On the 6th.
6. My lords.
Only 1 week in between.
My lords.
You also have your instructions from the
Clients.
And till when is he on leave? The other.
Till tomorrow.
So he'll be here on the 6th.
My lords.
In his presence, we can pass an order.
My lords.
In his absence, if we modify, because in the absence of the opposite party, there is always a chance of this. List this matter again on the 6th of October 2025 to enable the petitioner, counsel for the petitioner to have instructions on the queries raised by this court.
Highly
He
obliged.
said, we have raised a query, you find out your instructions, list on 6th. Okay.
Item 25.
Yes, item 25.
I passed on one document. I think this would answer both your lordship's queries. On by,
Yes.
I have approached now, and what is their confirmation? Lordships, may please, let's have a look. This is a letter dated 23rd September. This is in response to my representation dated 16th September. And my lords, here they say, if lordships would see para 2, on 18/9 was the pre-bid meeting where they say they have confirmed officially that no joint ventures, etc. would be allowed. Again, my lord, this document also has no reasoning as to why they have taken such a decision, such an exclusion, my lord.
Yes, what about 3?
Further, the tender
That again raises the question.
There is no condition restricting. There is absence.
There is an absence.
There is an absence. So I thought
joint ventures are not there.
I have two submissions, my lord. In that same tender document, they say pay us 10 lakh rupees and get the complete bidding documents, which I did on 20th of August, thinking that I would receive the complete documents and maybe there would be some provision. There was nothing, my lord. Then on 12/9, I attend the first pre-bid.
Then on
12th September.
So when did you take the documents?
My lord, 20th of August.
20th of
August, my lord.
August. Okay. Then you waited till 12/9.
12/9 was the pre-bid meeting scheduled, my lords. Before that, they were not entertaining, my lords. That is when they say that no, we will not allow. I sent a representation. In response, this is yesterday's letter, my lords. So, my lords, I have
This
tried
is-
23rd September.
No, you knew about it on 18/9.
Yes, 12/9 was the first pre-bid meeting.
Then you knew.
18/9.
So
And today is, my lord, 25th.
25th, yes.
So, it took me, my lord, 3-4 days to
If
file.
I know, if I understand you correctly, you came to know about it yesterday and therefore you are approaching today.
No, 18/9.
When did you file it?
With this petition, I
23rd.
I believe on Monday, my lords. Monday or Tuesday morning, my lords, we filed it. Or getting a counsel here, coordination, 2 petitioners are there, my lords, arranging documents, that took
You
some
see,
time.
we are talking of, the Supreme Court has been very, very, very clear on this.
Lordship.
No stopping public work.
So, but please see, prima facie, if I am able to, my lords, satisfy your lordship that this is something that's completely
All done.
arbitrary.
First thing,
Lordship.
it's a contract. You have to convince me. Then we'll hear her. You have to convince me. First thing, it's a contract.
Not yet, my lords.
It's a contract work. A contract work, the terms and conditions are between you and the state, or the
In fact,
person,
unilaterally theirs.
whoever is there, between two entities. Now, we take up matters regarding contracts only to see that there are no arbitrary acts by the state.
Yes.
Now, these kind of contracts it is not as if these contracts are unheard of, where joint ventures are not allowed.
In my respectful submission, unheard of. They can produce examples. I have not come across any. In fact, examples are to the contrary. And my lords, are they trying to benefit larger players?
Well, if that happens, save and accept you not being able to participate, what is the arbitrariness? They have said we are not allowing, if they are not allowing joint ventures.
Yes, my lord.
At all.
Yes, my lord.
What is the arbitrariness in that?
My lord, the fact that they have in effect excluded, I would say, smaller players who would pool in their resources, and then, so my lord, there are 2 petitioners here who are together fulfilling the eligibility criteria. But individually they are not. There may be more smaller players like me, like us, who may be willing to participate. My lord,
Even individual bidders are being allowed. So it is not.
But lordship may see the eligibility criteria. They are so restrictive. My lord, they are so restrictive that no smaller person can hope to even think of participating.
Can we look into that part? I'm not very conversant with that part of law where I can actually interfere because it is restrictive.
Well, I believe your lordships can exactly do that.
I can interfere perhaps when it is selective, but when it is restrictive,
Restrictive also, in my respectful
Show me
submission, basis, my lord, in fact, that INRE Natural Resources judgment, 2G, and one Bombay High Court judgment. Those only 2 judgments I am relying on. Let me just read out.
Restriction has to be perhaps understood as a restriction.
Bombay High Court says if this is unduly restrictive, they in fact quashed the tender on that ground. In that case, what had happened, DB, my lord, recent decision of the Honorable Bombay High Court, where, my lords, they said only PSUs can participate. So arbitrariness, Article 14, and unreasonably.
Only PSUs is another thing. Only PSUs is another thing.
I understand, my lord, slightly different context, but after all,
one sentence would make the whole lot of difference when we are trying to interfere in a contract.
at the heart of it, you have excluded certain persons who would together. So the moment you make a classification, 2 tests have to be fulfilled in my respectful submission: intelligible differentia and a nexus to the object sought to be achieved. Both are missing in this case in my respectful submission. Third, of course, absence of reasons behind any decision, which also makes it arbitrary.
If we go by your such arguments, then we have to give them the opportunity to answer before whether what is the reason why they have done it,
Lordship,
and how they relate it to a reasonable nexus.
Absolutely.
That we have to. We cannot stop anything. And how do we allow you to participate?
I don't think under the present tender I can at all participate. They will have to re-tender it if your lordship finds that this is illegal on any yardstick. So in the meanwhile, let them at least maintain status quo, my lords. Let them go ahead. Fair enough.
When is that next stage?
29th, my lord, is the last date for
submitting. Thereafter,
and 30th, they are opening the bids. That's the declaration of result. Within 15 days thereafter, they will issue the letter of intent. So nothing will remain.
Nothing. If it is within 15 days, then we can fix it for the 6th, keeping everything subject to outcome of the repetition. That we can do.
But if they issue, my lord, a letter of intent
on the 6th, see 29th and 30th. First, second, third, I am not. It's done on holidays also.
Sorry,
government holidays का list किधर है? No government holiday. So they would
They
still
would be working, we would be off, and in the meanwhile, a lot could happen.
You don't have a vacation bench? No vacation bench? For 1 week there is no vacation bench. No?
Well, let them do their exercise, but let them maintain status quo if your lordship should deem that appropriate, Manoj. At least, Manoj, then on 6th.
See, these are public projects of, I don't know, maintaining the hydropower stations.
But these are running stations and they have
Could
been
be,
running.
yes, could be, yes.
Now they want to outsource them.
But the thing is, your entity's personal
Both of us combined.
putting the stake at claim, or the people at stake is putting everybody to stake.
Only till the 6th, Manoj. Till your lordship examines it, Manoj. I'll be here, Manoj. We will be here to assist your lordship. They have to respond, Manoj.
The bidder can be a company registered under the Companies Act, Registration of Indian Companies Act, Limited Liability Partnership, or firm, or proprietor, or individual. Then I think all we can do is fix it at an early date, keeping everything subject to outcome of the writ petition.
Manoj, I am grateful that your lordships are indicating that, but our only concern is if in the meanwhile, and Manoj, if I am right, and if the intent is to benefit some large player, that's the exclusion. Smaller players now.
Then everybody will be in the soup. Why do you worry? We'll know who the large player is. We'll know who the state is trying to benefit.
It would also then prejudice that large player.
Surely, if they are playing a game, sure, so be it. If it is a game, and if it is not a game,
then
everything is fine, then everything goes back by the time they take for filing an affidavit in opposition, you making a reply to it, matter coming up at 3:45, no paucity of time today, and who takes care of the these substations during that time? Who will do it?
On that, can I answer? They are already running, and they've been running for a long time.
Someone is maintaining them.
Yes.
Who?
That's their intent.
Someone must be maintaining them. If it is the government itself, say they are not being able to do it, they want to give it to someone because they are not being able to manage it. Will we not be stalling that?
I would only suggest that if it's been stalled for so long, one more week. Lords may bound us down to time. We will come and argue, no further adjournments.
We are not apprehensive that you would be.
For both parties.
What we are doing is.
For both parties, no further pleadings required. It's a short question on law.
When we are not hearing them today, she has already prayed for time of 2 weeks, 2 days, at least.
At least.
At least 2 days. Then in those 2 days, how do you explain what he is trying to argue?
Yes,
that if you give the tender to someone, if you give the contract to someone,
yes,
everything goes.
if I may, in my humble understanding, now the applicant is challenging the criteria, and the state can make any criteria, whatever he likes. And suppose if he is not eligible on the criteria, on what ground he is challenging that criteria? In this notification, Your Lordship, it is well written that is in page 40 of their application. Page number 40.
Yes, sir, we can do 2 things. One, we can take into consideration everything that you have said, and we can give our reasons saying that we are not stalling the process.
Can I only?
Or I can say that looking at the urgency of the matter, we'll list it on the 6th, by which time the respondents will have their response ready, since it's a time-bound thing, and any steps taken hereinafter by the respondents shall be subject to the outcome of the writ petition and at the risk and cost.
Milords,
if they proceed.
I am grateful if that's what your lordships are inclined to do. Just one request, if your lordships would consider, my lord, saying that let them not finalize the tender process, because that becomes irreversible. My lord, let them open the bids, do whatever they want.
How does it become irreversible?
Oh, once they issue a letter of award, then the third party says, look, now my rights have crystallized.
Yes, they'll argue their rights. Can you oust
becomes
someone?
a mess.
It has to be. Had this approach been on the day you bought this piece of paper, where it said that we are allowing only this, because the eligibility criteria,
it is silent
page
on,
44.
It is silent on JVs and
No,
consortiums.
it is specific on who can apply.
Who can apply?
We
So
can
yes,
we can look at it in two ways.
Two ways, yes.
It is not that the government of Mizoram does not know about joint ventures. They knew, and it has been excluded.
Excluded.
Not into this is an inclusive.
I understand.
Inclusive thing.
Yes.
Which was in your knowledge. Given maybe this week, if given to the court and the respondents, they would have come up with some reply. This is why we don't want a joint venture. We would have said yes or no.
When clients read tender documents, maybe they don't read it with that precision which is falling from your lordships. That's why, my lord. But
You are talking you are talking in benefits of I don't know how much. Is it not? It's no one can question you saying that you did not read your brief well. Can they? No. It's a profession, is it not? Can anybody ask me, did you read the brief? You did not read the brief well. No. It's my profession. I read it. Right? So if the tenderer now, if the litigant now comes up to say, I didn't read it properly, your problem.
We were waiting for a confirmation which we received later, but I understand. My lord, fair enough, my lord.
What we can do is we'll make everything subject to outcome of the writ petition.
On merits, can I just show one thing? Just one.
Yes,
they have referred to a parent notification pursuant to which they have issued this. Please just have a look at one clause.
Yes.
It starts at page 65.
65.
Yes, my lord. It's annexure 2. It's a notification dated 20th April 2016.
Yes.
And my lord, we please have, my lord, clause at page 71, clause 8.
Page 71.
Lordship. Contractual arrangement. They themselves in the notification will see 8.4. So 8.3, 1C is where this tender falls according to their own tender, which is ROMT, rehabilitate, operate, maintain, transfer basis. This is under which they have issued the tender. 8.4, contractual arrangement depending on nature of the project for new infrastructure would typically include, besides others, options available.
It is there, the joint venture is there.
In the parent notification itself, they have contemplated.
This is what is holding your case, the nose of your case above the water for the time being.
They themselves have
If this clause was not there, the simple answer from the court would have been their choice. Sorry. Is it not? Since they recognize the joint venture, we have to keep the case above water.
That's one. My lord, second, if your lordship sees that Constitution bench judgment and also the Bombay High Court.
Show me the relevant part.
Yes, ma'am. Just 2 facts. If I may read first the thicker bundle, my lords. That's the Constitution bench.
Yes.
The Honorable Supreme Court. Your lordships may have notes. Para 107 of the majority opinion. This is at page 83 of the judgment. Note the small page numbers on the right. 83. Para 107.
Yes. Yes.
From a scrutiny of the trend of decisions, it is clearly perceivable that the action of the state, whether it relates to distribution of largesse, grant of contracts or allotment of land, is to be tested on the touchstone of Article 14 of the Constitution. A law may not be struck down for being arbitrary without pointing out a constitutional infirmity, as McDowell's case has said. Therefore, a state action has to be tested for constitutional infirmities, qua Article 14. The action has to be, Miller's may note, fair, reasonable, non-discriminatory, transparent, non-capricious, unbiased, without favoritism or nepotism, in pursuit of promotion of healthy competition and equitable treatment. It should conform to the norms which are rational, informed with reasons and guided by public interest. All these principles are inherent in the fundamental conception of Article 14. This is the mandate of Article 14. Yes. It violates at least 2 of these.
Which one?
Healthy competition.
Why?
You're excluding all and sundry My lord, if your lordship sees the eligibility
Not all
criteria,
and sundry.
100
They are excluding
people to come
they are-
together
no,
to
they are-
pool in their resources.
Huh?
They're excluding people from coming together,
Yes.
pooling their resources and participating in a...
That pulling in the resources and everything comes up in the form of a partnership. They allow a partnership, don't they, for a project. You can have a partner.
For that, my
partnership.
lord, I'll have to form a separate entity, a partnership.
Yes, that is what they want. One person responsible for the entire project, one entity responsible. If you say no, that was not my part in my joint venture, it was his part, look into him.
I understand.
There, it's a chaos. I am just trying to find out whether there can be reasons. I am not bringing them down in the order, but I am
Your
trying to
lordship
find
is
out.
absolutely right. But that could be answered perhaps in how the Sikkim government has dealt with it, where they have
Not
said who
necessary. They
will
are
be the
different.
prime bidder.
Sikkim is a different entity.
Or even the Uttarakhand
Assam is a
government.
different entity. Mizoram is a different entity. They'll have their own.
I'm only trying to say that apprehension of your lordships has been dealt with where they have made provisions allowing. Yes, my lord.
How things happen is this. See, you are using that iPad. You are using that iPad.
Yes, my lord.
I use it inside. The difficulty I face is I don't have this on my PDF.
I don't have
this. I don't have the files on PDF. So I can't go there. I can't do it there. Here I have to go through the pages. So every project will have its own uniqueness.
I was only
Can
trying
you
to
say that no, it happens in the Supreme Court? Make it happen here. Cannot.
I'm saying if you have the difficulty of fixing responsibility, that can be done even in a JV.
We
It has been done in the
no,
past.
they will say we are not required to. We have got other people.
The lordships are
Wait.
actually supplying reasons which will now we will see them in the form of an affidavit. my lord.
So let us do it this way. No, that will be different.
Well, I'm grateful for a patient.
See, I have been a lawyer too long.
I'm aware, my lord.
And I need to be very sure of what I'm doing. And yes, thinking aloud. Today I got a message.
To my
Thinking
friend's
aloud may not
benefit,
be.
to my friend's benefit, yes, your lordship thinking aloud will really now support their
Because whatever they have done before this bidding part is already on records. They will not be able to. They
have to supply reasons actually. my lord, that's
They will not substitute it. They will not now do anything. And I'm not going by something which comes on a piece of paper. It has to be the records as to why you took this step.
And that reasons must exist when you took this decision.
Exactly. If anything new now comes up, it's always your line to argue.
Absolutely. I'm most
So
grateful.
you will not be prejudiced in that.
Lordships
But
may-
what I'm trying to find out is if the moment I interfere, even temporarily, on a public project, it has to be a very strong reason. We have been taking up PILs, why not the roads? Why are you not building up roads? Why are you not doing that? We do that because we want things to happen
I
for the
understand
state.
that word of caution exists, my lord, where it's an infrastructure project. I understand.
And I'm actually I would be happier if this had come sometime in the month of August or maybe earlier part of September. We would have the time to see whether 107 would be applicable to your case. Had it been so, everything goes before they can start off.
Or they
But
could have
at
started
this stage,
afresh.
it is too late.
Fair enough, my lord.
For a complete, for a stay of the proceedings.
Lordship may not stay, my lord. I never even made that request. If your lordships would only consider, my lord, then I'm so grateful for this patient.
I'll only say that they would come up with
the reasons as they existed.
No, I'll only say that they'll have their reasons, their response.
Very well, very well.
Either by way of affidavit or by way of written instructions.
Very well,
to be placed before this court on the, yes madam, 6th.
On the 6th, yes.
6th? You don't have a holiday here. Government holiday to hai. There's no government holiday. 2nd is Gandhi Jayanti, it has to be. So you would have around 4-5 days. You asked for 2. On the 6th, either an affidavit or written instructions in
Yes,
response to the
6 will be 6 October.
Yes.
Yeah, 6 October is holiday for us. No, it's not
It's not,
holiday.
it's not.
Yes,
It's
yes.
a
I'm
holiday for
sorry,
me,
I'm
not for
sorry.
you.
Yes, Your Lordship.
So I'll fix it on the 6th. Be prepared with the written instructions or the affidavit
Yes,
to be placed before this court.
I will try.
Since urgency has been expressed and urgency is apparent,
Yes, Your Lordship.
and any action you take in between 29th to say 30th to the 6th will be subject to outcome of repetition. If they try to speed up the matter, create chaos, then God said, let there be light. We can only say, let there be chaos. Okay, heard. Your good name, sir?
Prithu Garg, my lords.
Prithu Garg, counsel appearing for the
Petitioners.
Petitioners. Also heard the learned counsel appearing for the state of Mizoram. Miss So-and-so, learned counsel appearing for the respondents. You'll appear for all the respondents?
Yes, Your Lordship, sole respondent.
No, there are three respondents.
Yes. All are states.
Mineko. It's three for all the respondents.
Yes, all the respondents.
Mr. Garg has submitted that where is the list of date? We'll make it as short as possible and submit it. Huh? C. That the respondent number 3 had issued the RFP for tender number. You will find it at page C. We will flag mark it. Dated 8/8/2025. To operate, to rehabilitate, operate, and maintain 7 small hydroelectric power stations on contractual arrangement basis in the state of Mizoram. The petitioner number 1 purchased the complete bidding documents on payment of a non-refundable fee of rupees 10 lakhs paid in the form of demand draft as required under clause 2.1 within bracket Roman 2 of the RFP. On 12/9/2025, while attending a pre-bid meeting, the respondent number 3 clarified that consortiums and joint ventures were not permitted to participate in the tender process. However, this was a verbal communication. Is it not?
Yes.
On 12/9 it was verbal?
Not.
The petitioner thereafter preferred a representation on 16/9/2025, requesting the respondents to reconsider their decision and to issue retender the work with terms that would permit participation of consortiums and joint ventures like the petitioners. Full stop. It was only on when no reply was received, the petitioners filed this petition on 23rd of September 2025. Full stop. On a mention being made for urgent listing, the matter was directed to be listed today. Full stop. Today, during the course of his arguments, Mr. Garg has produced the letter bearing number, you'll find this letter here, the number and everything, dated 23rd of September 2025, whereby the petitioners have been informed that participations through joint ventures or consortiums was not permitted, and only individual bidders or eligible group companies with 51% shareholding by the ultimate beneficiary owners are allowed to participate. Full stop. Mr. Garg has vehemently argued that keeping out joint ventures and consortiums from, don't write keeping out, say restricting the participation of joint ventures and consortiums in public bidding process is not healthy to a competitive bidding, and in a manner violates the opportunity of fair participation by such entities, full stop. He submits that such an action does not conform to the norms which can be said to be rational, informed with reasons, or guided by public interest, etc. Full stop. He therefore submits that the respondent number 3, he therefore submits that the respondents would be liable to be directed to retender the process allowing participation of joint ventures and consortiums, and during the pendency of this writ petition, he prays that the respondent number 3 should be restrained from proceeding further or finalizing the bids under the tender number so and so dated 882025 or 20 full stop. In the alternative, he prays for an order requiring the parties to maintain a status quo as of today with regard to the tender process, full stop. Next paragraph. Ms. So-and-so, learned counsel, appearing for the respondents, has at the outset prayed for some time to obtain her instructions on the contentions raised in the writ petition. She has, however, referred to clause, where was that? Yes, to clause 3.1 of the ROP to stress that there is no illegality in the respondents requiring respondents permitting company registered under the Companies Act 2013, Companies Act 1956 and the registration of the Indian Companies Act 1961, limited liability partnership or firms or proprietary public individuals only to participate in the tender process, full stop. She submits that this being a work having immense public which would affect the public immensely, since the maintenance, rehabilitation, operation of small hydro power stations are involved, the contentions raised by the petitioner can be considered and decided in its finality, however, after affording the respondents the opportunity to respond, Full stop. She has prayed that any interference of this court at this stage may not be in the interests of justice. Full stop. Issue notice returnable on 6th of October 2025. Since the respondents are represented, formal steps are dispensed with. However, the counsel for the petitioner shall serve a requisite number of extra copies on the counsel for the respondents by tomorrow. By tomorrow?
Yes, ma'am.
Tomorrow is a Friday. She will not be able to send it. Why don't you do it?
Because my friend tells me.
You have given her one copy. Extra copies? You need more?
No, Your Lordship, that will be enough.
Acha. Then you say it like this, formal steps are dispensed with. The counsel for the respondent has acknowledged receipt of copies of the writ petition. Full stop. The respondents shall either file their affidavit in opposition. No, then we cannot have it fixed on the 6th, because if they have to file it, they'll have to file it on the 6th. It can be taken up on the 7th.
I have not
Because it will be a holiday here. One day holiday, the registry does not remain open, so they cannot file it. They will not file it tomorrow, they'll file it on the 6th, even if they work day and night. So 6th they file it, 7th we take it up. They वो 6th हटा दीजिए. Issue notice returnable on the 7th. Full stop. The respondents may file their affidavit on or before the 6th of October 2025.
It's a Valmiki Jayanti on 7th. I hope it's not a holiday here.
No, it's blue here.
Very good.
The respondents may file their response by the 6th of October 2025 with advance copies to the learned counsel for the petitioner. Full stop. The prayer for interim stay shall be considered on the 7th of October after receipt of response of the respondent authorities. It is, however, provided that any action initiated by the respondent authorities henceforth shall be subject to the outcome of the writ petition. List on 7th of October 2010. That should suffice both the parties.
Grateful for this patient hearing.
Hearing list, item 11.
Mr. Jordan has requested an adjournment on his behalf in this case. He has requested
Item number 11.
11, my lord. He
At
has
the
some
request of the learned
unforeseen
counsel for
circumstance,
the-
my lord.
Uh-huh.
Maybe an unforeseen circumstance. He has to be out at the moment. Though the matter is fixed.
Let us pray everything is okay. Yes, at the request of the learned counsel for the petitioner, list this matter after the puja vacations. Both 11 and 13. 13 also Mr. Jordan is there, no? If there on item number 13, you write learned amicus curiae appearing for the learned amicus curiae, okay? In item 13, it will be amicus curiae, and in item number 11, it will be learned counsel appearing for the petitioner. Yes, thank you. ये लेके